Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. I was recently asked a question that I thought was interesting, and so I'm going to share it with you. And the question is, how important is a buyer walkthrough in post-closing litigation? The context being, if a buyer fails to do a walkthrough and then sues seller, claiming that seller failed to correct some condition that seller was required to correct, or that seller maybe took the washer and dryer when they were required to leave the washer and dryer. There's some post-closing dispute that buyer might have become aware of had buyer done that walkthrough. Well, the fact that buyer failed to do the walkthrough create a problem for buyer in prosecuting that complaint. And the answer is, who knows? As in all litigation, there are no guarantees. But certainly that's going to make buyer's claim more difficult, at least depending on the nature of the claim itself. Here's what I mean. If seller had an obligation to leave the washer and dryer, then seller had an obligation, a contractual obligation to leave the washer and dryer. And the fact that seller took it is not going to be overlooked by a court just because the buyer didn't notice that prior to closing by doing a walkthrough. But there is a really important issue that can come into play. Most buyers, when they sign their closing documents, they sign a statement as part of the escrow instructions, if nothing else, stating that all of the requirements of the purchase and sale agreement have been met. So if buyer doesn't do their walkthrough, doesn't know the washer and dryer is missing, signs a statement at closing saying that all the terms of the purchase and sale agreement have been met, and then later sues the seller for breach of contract claiming you took the washer and dryer when you weren't supposed to, that could make the buyer's argument more difficult. Or in another example, let's say it was a repair obligation. Let's say that seller was obligated to repaint the living room walls a specific color of gray. And buyer doesn't do the walkthrough. And seller has painted the walls. But buyer, after closing, says, whoa, hold the phone. This is not the color of gray that we agreed you would paint. I gave you a specific, paint manufacturer and color code number, etc. And this is not what you used. Seller may have a defense of saying, I did or I didn't, maybe whatever their argument is. But buyer, you had the opportunity to come through before closing and let me know if there was a problem with the painting that I did. You didn't do that. We've already closed. And as a result of that, you waived the opportunity to object to the painting that I did for you. Add on to that and to this notion of revisiting or doing a walkthrough with respect to repairs. Remember that while Form 21 has boilerplate language built into it, giving every buyer the right to walk through seller's home within 5 days prior to closing, remember that Form 35 also independently, the inspection contingency addendum, gives buyers the right to bring buyer's original home inspector back into seller's home to inspect the repairs that seller agreed to and hopefully made prior to closing. So with both of those walkthrough or reinspection opportunities, if buyer fails to take advantage of either or both of them and then wants to sue seller after closing for some condition on site that buyer probably should have become aware of prior to closing, even if that failure to do the inspection doesn't defeat buyer's claim, buyer should know that the fact that they failed to take advantage of their contractually entitled walkthrough or reinspection is likely to cause an issue in their litigation. It's going to be a defense by seller that the buyer is going to have to overcome. So buyer brokers, the point of this communication is make sure that you have advised your buyer of their rights to do the walkthrough based on the Form 21 within 5 days prior to closing, and to hire their inspector, their original inspector, to come back and re-inspect the work that seller did. If buyer doesn't want to do those things, I don't care. What I care about is that you have advised them to do it and that you've documented that advice. So, as with all advice that you give to a client, make sure you put in writing the fact that you're reminding the buyer of their walkthrough and reinspection right, and delivering that information to the buyer in a provable way. The buyer is certainly going to need your assistance to get both of those scheduled if they want to take advantage of those opportunities. So you ought to include the invitation to help them get those scheduled in your communication to them, reminding them of their right to conduct these inspections, or the reinspection and the walkthrough. Again, whether they do it or not, up to them. All that you can control is delivering the reminder to them of their opportunity and really the importance of doing those. If you have questions on these topics or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.
Ha 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 ha!